Just don't close it.
All right, you guys, we're gonna go ahead and get started. Shh. Okay. My name is Jace Breedlove. I'm the president of the Federalist Society. If you haven't met, hello. Welcome to our first event of the semester. A couple announcements first. Please check in if you haven't. I'll put the QR code, or I'll leave it up there during the event. Okay, Monday we're doing a Constitution Day lunch. Just a small lunch. First 10 people that respond to Miranda Cassidy will pay for your lunch. So that's Monday. Next Wednesday is our next event. You can RSVP on SMU 360. It'll be in Florence 201, and it'll be an introduction to originalism. So hope to see you there. A couple other things to mark your calendars. Our last two events of the semester will be October 26th. That'll be an affirmative action event with Professor Brian Fitzpatrick of Vanderbilt. And on Halloween, Fifth Circuit Judge Jennifer Elrod will be coming to give a talk. So those are all also up on SMU 360. So I'd encourage you to go ahead and register now. And that'll be up during the event. Please check in. A quick note about checking in. Eligibility to vote in the elections at the end of the year are based on how many events you've been to.
Hold on, is anyone disqualified for insurrection here? Just anyone in the January 6th rule, or you all?
You also can't have been involved in that. But you have to have been to at least two events. So please check in. Even if you're not interested in voting, please check in. Okay. Without further ado, I'm going to introduce our speakers. First, we have Stephen Hammer. Stephen is an associate in the Dallas office of Gibson, Dunn & Crutcher, where he's a member of the firm's appellate and constitutional law and administrative law and regulatory practice groups. He served as a law clerk to Chief Justice John Roberts of the United States Supreme Court, and before that to Judge Jeffrey Sutton on the Sixth Circuit and Judge Gregory Katsas on the DC Circuit. Mr. Hammer attended Harvard Law School, where he served as a managing editor of the Harvard Journal of Law and Public Policy. Before law school, he served as an infantry officer in the 82nd Airborne Division and deployed twice to southern Afghanistan. Mr. Hammer received a Master of Philosophy and Theology from Oxford and a Bachelor of Arts and Classics from Princeton. Just a note, I had to cut down both of these bios significantly, so if you think that's impressive, there's more. Josh Blackman is a national thought leader on constitutional law in the U.S. Supreme Court. He has testified before Congress, regularly appears on TV, is a frequent guest on NPR and other syndicated radio programs, and has published commentaries in the New York Times, Wall Street Journal, and other leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law, Houston, where he holds the Centennial Chair of Constitutional Law. Josh is also an adjunct scholar at the Cato Institute and a prolific writer, having authored 3 books and more than 6 law review articles that have been cited nearly 1,000 times. And a fun fact, his forthcoming article on affirmative action will be published in SMU Law Review's Symposium issue next year. So,
I'm sorry with the footnotes in advance.
So with that, I'll hand it over to Professor Blackman.
Thank you so much. Thank you. It's a pleasure to be here with Steve to talk to you about the Supreme Court. So the term that just finished was different than the prior term. 1 year before, the Supreme Court overruled Roe against Wade. They killed the so-called Lemon Test. They expanded the Second Amendment outside the home. In almost every case, it seemed that the conservative side of the court was winning. In fact, almost none of the 5-4 cases went against the conservatives. What about the term that just finished? It was without question a conservative-ish term. That is, the conservatives won many, if not most of the big cases, but less so than the prior year. At one point to stress, the decisions of the court to decide that were apparently conservative had a lot of public support behind them. I'll give you some numbers from an ABC News poll. The affirmative action decision, which Stephen will talk about in a few moments, 52% agreed with it. Only 42% disagreed. Okay. The case of 303 Creative, which I'll talk about, whether a website designer must design a website for a same-sex wedding, 43% approved, 42% disapproved. That's pretty close. The student debt decision, 45% approved, 40% disagreed. So if you look at the term as a whole, this was not a right-wing landslide, perhaps as was the year before. Last term, 14 of the 60 opinions split 6-3, with conservatives on one side, liberals on the other. Again, it was 14 out of 60. What was that this year? 5 out of 58. So there were far fewer cases where everyone sort of just split on their own sides. Last term, there were 10 5-4 decisions in which all of the liberal justices stuck together. This term, there were only 6 5-4s, and 4 of them, the liberal bloc prevailed. So actually, the liberals of the court are pulling in Justice Kavanaugh and my good friend's former employer, Chief Justice Roberts, on not a regular occasion, but increasingly often. Moreover, half the cases this term were unanimous, and those affected things like religious liberty and otherwise. And at least one liberal justice was in the majority in almost 90% of the cases. And all 3 of the liberals were in the majority in about 2/3 of the divided cases. And this is just a gap that we didn't see the year before. Okay, so let's actually break down the numbers a little bit more. This is not the case always of the Chief Justice during the liberals in dissent. Indeed, of the 6 5-4 cases, Justice Thomas and Justice Gorsuch each joined the liberals in dissent once. So there's a lot of cross-pollination. So without question, I think this court will achieve conservative outcomes, but this is not the sort of court you hear about in cable news where it's this right-wing flame-throwing court. It's simply just not accurate. And we don't hear as the cases the court turned away. The court declined reviewing cases involving guns, transgender sports, access to medication, abortion, and so on. So even of the cases that they don't take, the court is not quite running to the right, as some may think. Now let's talk about the chief. And again, my good friend Steve clerked for the chief a couple of years ago. We'll talk a lot about John Roberts. Is he in control? Well, the chief has a unique power in that if he's in the majority, he can assign who writes the opinion. And in almost all the big cases, as Stephen will attest, he keeps a lot of them for himself. As for the justice who's in the majority the most, it's actually Justice Kavanaugh. Justice Kavanaugh is in the majority 96% of the time. That's a high number. That's almost higher than Justice Kennedy was at his peak. So it's very rare that Justice Kavanaugh is in dissent. But who's in second place? The chief. The chief is in the majority 95% of the time. These are very close. Who's next up? Justice Amy Coney Barrett. She's in the majority about 91% of the time. So between this troika of Kavanaugh, Roberts, and Barrett, 90% of the time they're in the majority. Wherever they are, that is where the court is. So for generation, it felt like Justice Kennedy was the locus, right? Wherever he was, that's where the court was. But now it's one or two of those, either Roberts and Kavanaugh, Kavanaugh and Barrett, Roberts and Barrett. Those two more or less decide the trajectory of the court. Now, what about the rest of them? If I were to tell you who's in the majority more, Justice Clarence Thomas or Justice Ketanji Brown Jackson, what would you say? Of course, Thomas, right? Wrong. Justice Thomas was only in the majority 76% of the time. Jackson was in the 80s. So Justice Jackson, the newest member of the court, is in the majority more often than the leader of the court's conservative wing. Again, this is not the court some people had hoped for. I'll put it that way. This is not, as I say, the Supreme Court is not the Fifth Circuit. If Trump had picked any of the Texas judges, we'd have a very different court. But that's not what he did. Who agrees, who disagrees? Well, it's not surprising that Justice Alito and Thomas disagree with the liberals about half the time, but Roberts and Kavanaugh sort of always pull together. Okay, so now we'll talk about a few of the big cases this term. I will start with an election law case, Moore against Harper. This case was billed as this cataclysmic decision that could upset democracy everywhere. Why? Well, if you read the Constitution, it says that states have power over elections. Okay, well, that's not controversial, but if you read the text, it says the state legislature can set the rules for elections. The state legislatures. It doesn't say the state courts, doesn't say the state executive, it's the state legislature. Does that mean that the state courts have no role in enforcing federal election law? This issue came up during the Bush v. Gore litigation when most of you probably not even born yet, but there was an issue. Did the Florida Supreme Court even have the power to override the decision of the legislature but how to count ballots? The Supreme Court hinted at this in a concurrence by Chief Justice Rehnquist, and the idea sort of percolated for more or less 2 decades. And the argument was that the Constitution says the legislature has this power, and that means the legislature, not the other branches of the state government. This theory came to be known as Independent State Legislature Doctrine, ISL, Islamic State, the ISL, the Independent State Legislature Doctrine. Remember ISIL? Remember that? ISIS? No, we don't talk about that anymore. And the question was, did the state court in North Carolina have the power to basically modify the way elections are held? All right, so the case is extremely complex. And the reason why it became complex is that originally the North Carolina Supreme Court had a majority of Democrat appointees, and they ruled in favor of the court's own power, right? After the case was decided, and after the Supreme Court granted review, there was an election, and the court flipped to Republican majority. And in a really complex, convoluted way, and I'm not going to try to explain it, the new Republican majority said, okay, we're going to change our mind, we're going to modify the precedent, but leave the old judgment in place. And if that makes no sense, don't worry about it. But the upshot is, by the time this case was decided by the Supreme Court, the North Carolina Supreme Court no longer stood by its prior decision. The judgment remained. So then there's a question of, is there even an injury, right? Is this case moot, right? Is there anything even that can be done? So you had a majority opinion by Justice Roberts, who, and again, I love the chief, but I don't agree with it. But he said that, well, the judgment still exists, even if the precedent's been overruled, we'll decide this anyway. From a policy perspective, that was probably the right call because we need clarity on this issue. But I think Justice Thomas's dissent had the better case. This case should have been dismissed. There's nothing to be done, right? The state courts handled it themselves. But then there was a question of what legislature actually means. And the Chief Justice more or less rejected the broad reading in independent state legislature doctrine. Said, well, legislature means legislature, but there's still a state government, and courts have the power of review. And even at the time of framing, courts have this power of review. So no, North Carolina legislature, you lose. But Roberts said, but there still might be cases where a court could go too far. And Justice Kavanaugh does what he always does. He has a concurrence. He always has concurrence. He says, well, there might be some circumstances where things are different, and I'll think about it at the time. Always leaving the door open, right? So this case was not the sort of cataclysmic collapse of the republic that people perhaps feared, but they at least left open the possibility that courts cannot go too far. The upshot of this case, though, is that now you have state courts in both Republican states and Democratic states who have power. And so you might have a rogue left-wing court in Wisconsin and a rogue right-wing court in North Carolina who can engage in changes to the electoral rules, perhaps not as intended by the legislatures. All right, that's case number one. Second case affects you all more directly. Student loans. Okay, just show of hands. How many are student loans? Every hand's up, right? I paid mine off about a decade after I graduated from law school. It was one of the best moments of my life. I was like, oh my God, yes, I'm so proud that I put in a percentage of my paycheck every month, and I'm a law professor. I'm not making a lot of money like some of you guys will. I was a law professor, but I paid it off anyway. Man, was I an idiot. I should just wait for student loan relief, right? Why did I blow all that cash to pay off my own debts? Well, it started actually during the pandemic, where the Trump administration said, well, we have this pandemic, things are bad. We're going to put a hold on accruing interest in student loans. We just will not accrue interest or penalties. And oh, by the way, you don't have to make any payments. Okay. This was the policy from DeVos, the Trump Secretary of Education. And the basis of this was a law passed after 9/11 called the HEROES Act. It was meant to say, if you are going overseas to fight in Iraq and Afghanistan, we're going to pause your student loan payments and not put you in foreclosure and in default because you're fighting for freedom, right? So the secretary had the power to, quote, waive or modify certain statutes and regulations in a case of an emergency. 9/11 was such an emergency. And so the Trump Education Department said, okay, COVID emergency, we're going to suspend the payments. No one complained too loudly at the time. I think people were focusing on other things. This policy continued throughout the year of Trump, and then after he left office, eventually, it goes to the Biden administration. And the Biden administration says, hold my beer. They said, okay, not only are we going to pause the accrual of interest and penalties, we're going to just cancel debt altogether, just wipe it out. And that is fairly elaborate formula. If we had so much debt and you had this much and this much, they just canceled debt. to the tune of billions of dollars of debt. I mean, just a staggering amount of money. And the question is, does the statute, which says you can waive or modify statutes and regulations, permit them to cancel billions of dollars of debt? So one thing to note is that Congress considered this issue. There were lots of bills on the table that would have eliminated student debt. And those bills did not pass muster. They didn't get over the hump, right? Congress rejected those. Is that relevant? Do we look at the bills that Congress did not enact to interpret bills they did enact? Are we good textualists for doing so? Didn't Justice Scalia tell us, no legislative history, don't look at what happened, and definitely don't look at what didn't happen, right? Isn't that what Scalia told us? The case goes to the courts, and the biggest challenge here is not actually the merits. The biggest challenge is what I'm doing right now, standing, right? Who has the power to challenge this in court? Now, what's weird about this policy is it doesn't really inflict an injury in the sense you might think. The government is alleviating a burden. It's removing debt, right? If you owed $100 yesterday and you owe $0 today, are you injured by that? Would anyone complain about that? No. So the challenge of this case was finding someone, anyone for the love of God, who has standing, right? So there was one guy, you on this case or no? No, you didn't this case. Mr. Brown, no, it's constable. There was one guy in Texas, his name was Mr. Brown. Again, the case is called Brown versus Department of Education. Someone has a sense of humor. Yeah, so you got that one. Good, paying attention. Brown versus Department of Education. He said, well, wait a minute. I'm not eligible, right? You give all these people debt relief. I want debt relief. So where's my money? That didn't work. And really, I mean, the remedy they were seeking was to strike down the rule so that no one would get it, because you level down, right? He's complaining he can get the relief, and then the remedy is no one gets relief. Okay, that didn't work. Another party was successful. MOHELA, not Mahalo, MOHELA, MOHELA, the Missouri Higher Education Loan Authority. This is an entity, quasi-governmental in Missouri, the specifics I'll get to in a moment, that administers loans. Okay, now, if you administer loans, you get fees and you get various money accrued when you service loans, right? If the government just wipes out all of this debt, you won't get your fees. That's an injury. And the government basically agreed that if MOHELA was a party, they would have injury in fact, they would have standing. But, MOHELA did not bring the lawsuit. Who brought the lawsuit? The Missouri Attorney General. The Missouri Attorney General brought the lawsuit on behalf of this entity. So the standing inquiry actually came down to, does the Missouri AG have the authority to represent MOHELA? Now, this is a question of state law. And in fairness, the Chief Justice wrote an opinion again. I don't know if he's right. I have no idea. But the Chief said, yeah, this is a state entity that's good enough. He found some old Missouri case that sort of said what he wanted to. That's good enough. I don't know. It's sort of a weird question. But on the merits, the court was 6-3. Okay? On the merits, the court was 6-3. And this brings us to something called the major, not the minor, the major question doctrine. You guys heard of this, right? This wasn't a thing when I was in law school, right? This really came on the last couple of years. So what is the major question doctrine? Well, Justice Scalia described it memorably. He said, Congress doesn't hide elephants in mouse holes. If there's something really big that Congress wants to do, they're going to say it expressly, right? If Congress wants to wipe out $200 billion of student loans, they better damn well do it clear. It's a clear statement rule, I think. And if you look at the HEROES Act, there's no evidence in 2001 that they wanted to do this, that this is such a broad expansion of power. So what the Chief basically said is the statute doesn't support this, and this is such a drastic departure from prior law that we can't support it. Justice Barrett had a concurrence saying, well, we can think of the major question doctrine as sort of a canon of interpretation, look at context. I'm not sure how persuasive it is, but she's at least thinking about it. And Justice Kagan, oh man, she does not like this. Justice Kagan was livid, saying, oh yeah, we're all textualists except when we're not textualists, right? How are we looking at a bill that was not enacted to interpret text that was enacted? And she has a point, right? I mean, Kagan is just very adamant that this is not real textualist, and she's not happy with this approach of law. But the court seems to have 5 or 6 justices who are committed to the major question doctrine, perhaps for varying reasons. I don't think Barrett and Gorsuch agree. In fact, I think Barrett and Gorsuch don't agree. If I had to put the money down, I think actually Barrett's in the minority on this one, but whatever. There's 6 votes to agree with the doctrine. and it's there. So if any of you are hoping your loans will be wiped out by this, too bad. You can thank the state of Missouri and their elected officials who set nationwide policy, as it were. Okay. The last case I want to talk about involves free speech. You may recall a case from common law decided about 5 years ago called Masterpiece Cake Shop. Jack Phillips is a baker in Colorado. I've actually been to his shop. I was so annoyed. I went to go speak at the Denver Law School, and I went out to his bake shop, and he wasn't there. There's a sign there saying closed for vacation. I'm like, oh man, I want to see his cake shop, and it was closed. So unfortunately, I didn't see it. But Jack Phillips is a baker. He's also a Christian, and he did not want to make a cake for a gay wedding. So a couple walks in, they want a cake, and this story is long and convoluted, and eventually he says, I'm sorry, I can't make you this cake. The Colorado government proceeds to basically impose fines against him. The case goes to the Supreme Court. So there were two ways the court could have resolved Masterpiece. One on free speech, second on free exercise, because they're closely related. He had a speech right not to make the cake, he argued, and he had a religious objection to supporting a gay wedding. Okay. The Supreme Court chose door number two. The Supreme Court decided the case on the basis of religion, and in a very unusual fashion. There was some evidence in the record that members of the Colorado government made statements that were frankly hostile to religion. They did. They said, we can't let people use religion as a shield for bigotry, that, we need to be more modern and so on. And there were statements that were hostile to religion. So the court wrote an opinion. This was Justice Kennedy's last term, by the way. The court wrote an opinion saying, well, there's evidence of animus. This is what Justice Kennedy loved, the word animus. He loved that word. And when the government officials engage in animus, it's not good. Can't do that. But by doing so, Kennedy was able to avoid the real issue, which is compelled speech, right? Can the government make you speak, convey a message that you do not want to convey? So, for example, if your license plate, New Hampshire, live free or die, they make you the license plate. Can they make you salute the American flag? The answer is no and no, right? The government can't make us convey a message. And Justice Jackson said, if there's any fixed star in our constitutional constellation, it's that the government cannot prescribe what ideas are orthodox. You can't tell us what to say. But is a cake speech? The court didn't decide that. All right. Fast forward a couple years, and we go back to the great state of Colorado. It's always Colorado. I don't know what it is about Colorado. Maybe it's a mile high. It's the marijuana. I don't know. But it's always Colorado. Maybe lightheadedness, whatever it is, right? And here we have Lori Smith. She has a company called 303 Creative. And I'm going to be very careful with the facts. She said that she designs websites for weddings. Did she ever actually do it? We don't know for sure, but the record says she does. And she said, I am afraid that someone will ask me to make a website for a gay wedding, and if they make such a request, I'll have to decline. She brought a lawsuit. No one ever, let me phrase this very carefully, before her lawsuit was filed, there's no evidence anyone ever asked her to build a website for a gay wedding. After she filed, she claimed she got an email where someone asked her, although it turned out to be not accurate, but that's actually not important because standing is formed the moment the complaint's filed. A big hurdle here again was standing. How can you sue when no one's actually asked you to make the website yet? So there's some cases, there's some doctrine, what's called a pre-enforcement challenge. That is, if you have a credible fear of prosecution, that you can bring the lawsuit in advance. And this is not conservative case law. This is actually progressive case law. People have been bringing civil rights actions against conservatives for decades on this exact basis, but now people don't like it. Colorado, for whatever reason, basically stipulated to a lot of things. And they basically said that, yeah, if someone actually made this request, you'd be required to build a website. So Colorado more or less stipulated its way into Article 3 standing. I think Lori Smith had standing. I can be persuaded otherwise, but the fact that Colorado stipulated, I think, does make a big difference. So the case goes to the court. Justice Gorsuch says, Colorado, and that's where he's from, Colorado stipulated, so we have standing. All right. Then it goes to the free speech angle. And Justice Gorsuch has this rousing defense of free speech. He talks about West Virginia versus Barnett, the flag suit case, that you can't force people to engage in speech they disagree with. A website is obviously speech. I'm not sure if baking a cake is speech, but a website is, and the website designer prevailed. Again, this was a 6-3 decision. Justice Sotomayor had the dissent, and she argued this was the first time that the government actually created a carve-out for a discrimination law. That is, you have a discrimination law, now there's a carve-out for those who engage in so-called religious speech, and she's sort of very dismissive of this idea. The upshot is, if Sotomayor prevailed, that you'd be forced to engage in building the website whether you want to or not, or you can just quit your job and do something else. Go do something else, make something else. This opinion will have fallout. We don't quite know where it's going to wind up, but it's very significant. All right, I've talked enough. Let me turn over to my good friend Stephen and look forward to your questions later. Thank you so much.